Hello, my name is Ali Shahir Kiani and I'm a student of LLB second year of the University of Hertfordshire, Hatfield, and my student ID is 24112199. And here's my Team UC student ID card. So now I'm going to start with my presentation. So first of all, I'm going to give you a brief overview of the scenario. So firstly, Hareem, who was a reseller, she ordered jewelry from Rivaj UK. Rivaj UK was a store which sold jewelries and some other stuff related to that. So Sana was the manager there and who dealt with Hareem, and they agreed upon some things, and Hareem agreed to pay for that and paid for it. Secondly, the goods delivered from the store Rivaj UK to Hareem, they were defective and non-compliant. They were not according to what Hareem has paid for and Hareem and Sana had agreed upon. And thirdly, when Hareem contacted the store Rivaj UK and Sana for refunds and exchanges, so the store refused the refund and exchanges, citing their no refund and no exchange policies. So the key legal issues, we're going to discuss the key legal issues. Firstly, Hareem can go for the hypoallergic claim. Basically, under the Section 14 of the Sales of the Goods Act 1979, there is a clear breach of description and fitness for purpose. So the thing was that Hareem had taken surety from Sana, that Hareem firstly told Sana that she's gonna need the jewelry sets and which are gonna be hypoallergic, because some of her models, they were allergic to some kind of jewelry, and she wanted her jewelry not to be made of pure gold and other stuff uh, other than titanium. So firstly, this is the thing, and secondly, the breach of satisfactory quality and under section 14.2 of the Sales of Goods Act 1979. The problem here was that Hareem ordered 5 rings, and in which there were gems were missing from 3 of the rings, and 2 were in good condition. So there is a breach of satisfactory quality. And thirdly, incorrect delivery, because the choker sets she ordered, they were not delivered as agreed upon, and the color was not same, the quantity was not same. So she can under the section 30 of the Sales of Goods Act 1979, we can Harim can claim about the incorrect delivery, because the choker sets she got delivered, they were not according to what they Sana and Harim agreed upon. So lastly, the exclusion clauses. Store's no refund policy. When Harim contacted Sana and Rivaj UK for the refund, so they denied her refund because stating there no refund policy. So that's an exclusion clause. So now I'm going to move on to the issue one, which is the hypoallergic requirement under the section 14 of the Sales of Goods Act 1979. So under this section, goods must be fit for a specific purpose made known to the seller. And I've cited the case of Baldry versus Marshall in 1925. So basically, the thing was that Harim required that the jewelry set and the jhumka earrings, matching jhumka earrings, Harim required, she took surety from Sana that they are gonna be hypoallergic, because her models were allergic to stuff other than titanium. So the breach was that the jewelry caused allergic reaction despite assurance. So that's breach. And now we're going to talk about the remedy. Hareem can reject the goods and claim damages for breach. So as she have got claimed the good, she have already gotten the goods. So now she has only one option left as a remedy, and which is that she's going to claim damages for breach. So the issue number two is the missing gems in the rings. Under the section 14.2 of the Sales of the Goods Act 1979, goods must be of satisfactory quality, and I've cited the case. So in this case, they were not of the satisfactory quality. 3 of the 5 rings didn't have gems with them. The gems were missing. Only 2 were in good condition. So the remedy, we're going to talk about the remedy. In this case, in this scenario, Harim has the right to reject non-conforming goods under Section 15A of the Sales of the Goods Act 1979. Moving on to the issue number 3, incorrect delivery of chokers, Section 30, SOGA 1979. So under Section 30, seller must deliver exact quantity and description ordered. So in this case scenario, the breach was this, that only 4 blue, 8 maroon, not 10 each, and unsolicited green sets were delivered, whereas Hareem ordered 10 blue and 10 maroon sets. So I've cited a case of Remove and Landover 1921, which clearly allows rejection for incorrect quantities. Now I'm going to talk about the remedy that Hareem has. Hareem can refuse the partial delivery or claim any damages. And then now I'm going to move to the exclusion clauses and consumer rights. So the UCTA, Unfair Contract Terms Act 1979, it allows Harim to reject the goods because sorry, not to reject the goods. It is the store's no refund. It states that the store's no refund policy may be unenforceable if unfair. And I have cited the case of Photo Production Limited and Social and 1980. So, and the Consumer Rights Act in 2015, if applicable, strengthens buyer protection. So, this is the thing that Harim can challenge in court. So now we're going to talk only about the remedies available to Hareem. Firstly, rejection of goods in the Section 35 of the Sales of the Goods Act 1979. Second is the damages for the breach of contract. Section 53 is the Sales of the Goods Act 1979. And third is the specific performance. It is rare but possible. So, according to this, these are the remedies that are available for Hareem. Rejection of goods because she didn't receive the goods. Number two is a damage or breach of contracts because the goods she received was not up to the quality and quantity uh, which the Sana and Hareem had agreed upon. So, this is some of the steps that Hareem should take. Firstly, Reem should write a formal written complaint to Rivaj UK store and demand a refund replacement, which she did, and they cited their no refund and no exchange policy in return. So, secondly, she can do that. She could collect all the document evidence, for example, the photos of the defects of the products and medical report for the allergies caused to the models after wearing the sets that were non-hypoallergic. And thirdly, she can take legal action via small claims court if unresolved, and she should take it. And my advice would be that she should do it right away. She should do it swiftly and move her towards escalated legal uh, case scenarios if required. And lastly, relevant case law summary. These are some of the cases that support my statement and support Hareem's statement and her arguments and the scenario. First is Baldry v. Marshall 1925, which is fitness for purpose. Second is Rogers v. Parrish 1987, which is for the satisfactory quality. Third is Photo Production Ltd versus Secure Reoccur 1980, which is unfair terms. So in conclusion, Hareem has strong grounds for rejection and refund, and secondly, the store's policy does not override the statutory rights, so they're gonna provide her refund and she can demand refund. So thirdly, the recommended action is that she should demand full refund plus she should consider legal claim if the store doesn't cooperate with her. And my advice would be that she should act swiftly and take strict legal action against them, and she can sue them for approximately, she can claim approximately £10,000 according to me. This is my advice to Ring. So these are the references. The first one is the Sales of the Goods Act 1979, and the second is Unfair Contract Terms Act 1977, and the third is key case law as cited in the ninth slide.